was not able to be here in our first webinar in February, but fortunately I'm able to attend today. We are going to have a second webinar on the topic of personal data protection and the Digital Markets Act, which is, as you all know, an incredibly important topic these days in EU law. This will be, I think, our second webinar in English. The next two will be in Portuguese. And we do this because we have this way the opportunity to have a broad range of speakers. And today we'll have two speakers, one which is a former alumni of Nova, and Meneses, who works currently in Brussels. She will be presented shortly, and also Konstantina, Bania, who will join us later in this webinar. So thank you so much for being here. It's really a pleasure to once again organize this annual cycle of webinars within the Observatório of Proteção, Dados, and within, for the last year, the German module DATAporEU. Today, to moderate our panel, we're going to have Thais, who is since very recently a member of Observatório da Proteção de Dados. Thais, thank you so much for joining Observatório, and also for helping Diogo Brandão, who has been one of the souls of this idea of organizing this cycle of webinars. And thank you so much for helping with the organization of this webinar. So this is it from me. I'll give the floor to Thais to take the helm of this panel on personal data protection and the Digital Markets Act. Thais.
Okay, so good afternoon, everyone. I'm Thais. I'm a master's student at Nova's Master in Small and Technology. I would like firstly to thank Professor Grauce and Professor Francisco Coutinho for the honor of being in charge of the moderation of this session, and also Joe for his patience. So welcome to one more session of our webinar cycle on data protection promoted by the Observatório de Proteção de Dados Pessoais. Our topic today is the Personal Data Protection and the Digital Markets Act. First of all, I would like to thank everyone's presence here, especially our speakers, Konstantina, Bania, and Ana Sofia de Meneses, for kindly accepting our invitation to share some knowledge and thoughts with us today in the session. We are really glad you're all here. So, as already said, we have today with us two guest speakers, Ana Sofia de Meneses, who has a master in IP and ICT law, and also in private international law. Ana Sofia advises companies in the fields of EU data privacy, cybersecurity, and consumer law, and also works as an associate lawyer at Covington and Burling LLP. We will also have here with us today Dr. Konstantina Bania, who is a competition and digital regulation expert. And thank you again, the both of you, for accepting our invitation. We are now hearing to our speakers' thoughts, and we will have a moment afterwards for questions or insights before ending the session. So, Ana Sofia, first, thank you again, welcome, and the floor is yours, please.
Thank you very much, Thais. And first of all, thank you everyone, first for inviting me, and then second for being here to listen to me and Konstantina speak about this very interesting topic, so data protection and the Digital Markets Act. I'm very happy to speak at this event organized by my old faculty, the one where I did my bachelor's degree. And I'm also very happy because this is a very interesting topic. So Personal Data Protection, Digital Markets Act. It's interesting to see how data protection now is converging with many other areas. Competition law is one of those areas. Other areas include, for example, consumer law. But now specifically on competition law, there has been clearly a shift I've seen in the past years on competition law being one segment, one department, and privacy being another, and those being treated as separately. And clearly in the past, they were being treated as separately. And as I was preparing for this seminar, I looked back at Commissioner Vestager's different speeches on competition law and data protection. And I came across this speech she gave in 2016 in Munich at the time after a big merger investigation. And she mentioned there specifically privacy and competition concerns should be considered separately. So in the context of that investigation, the Commission considered that the transaction did not raise competition concerns resulting from the possible post-merger combination of data. So back in 2016, which is not that long ago, the convergence combination of data was not really a concern for competition lawyers. Well, this has clearly changed now, not only with the Digital Markets Act, but also before. And there is some history, especially in Germany, with the German Bundeskartellamt and German law looking into how combining data can actually lead to companies holding a dominant position in the market, because they take advantage of that data and are able, therefore, to be more competitive than other companies. So in the past years, competition authorities have recognized this, and now it's clear with the Digital Markets Act at the EU level that competition authorities should also be looking at privacy concerns. And then I had the privilege last year to attend a conference organized by the Data Protection Supervisor here in Brussels. It was organized in June, and Commissioner Vestager was there, and she gave a speech. And this time her speech was very different from the one in 2016. This time she mentioned specifically, well, data is an important element of competition in digital markets and an important part of our work as regulators. And she continued by saying we need to address common issues, such as the interplay between data protection and competition. Privacy and competition sometimes go together, but then she also mentioned that sometimes they don't. And this requires dialogue between regulators. So what does this actually mean? Well, it means for us lawyers and practitioners in the law that I'm able to work more closely with my competition colleagues. They need to understand what are the concerns in data protection, and I need to have some understanding of what are their concerns, because the objectives of data protection and the objectives of competition law are not exactly the same. And also, just to finalize the point about it being recognized that competition authorities can look at data protection. We also have, from September of last year, an opinion by the Advocate General of the Court of Justice of the EU in case C-252/21, saying that competition authorities can clearly look at data protection. I think someone is not mute. Oh, great. Okay. and so based on all this, the opinion of the Advocate General really culminating all this, it's clear that now when we look at data combination, we have to raise both with our clients' concerns on our data protection and competition law, and we have to work with our competition lawyers, which it makes work quite interesting. I'll pass it on now to Konstantina, if she's already on.
Yes, of course. Of course. Many thanks, Anna. That was a very useful overview. I hope you can hear me clearly. That's my only concern, because I can hear you. Very good. So excellent. Anna, many thanks. That was an excellent overview of how things have changed. You know, when I consider merger control and trust in days of acceptance. So first we had denial. We had authorities because it was explicitly stated in many decisions and also in press releases, statements and speeches that competition law had nothing to do with data protection and data privacy specifically. I can think of the Google DoubleClick case. That was a merger decision, and it concerned, as you know, the acquisition of DoubleClick by Google. At the time, many privacy activists raised the concern that, these are data-driven markets, and we need to consider the effect on data-driven competition. And the Commission was very keen to explain in its decision that competition law has nothing to do with data protection. Competition law is only considered with efficiencies, and if a merger does not create a harm to competition, it should be approved. Data protection should be addressed by data protection authorities, data protection regulation at the time, and that was the end of the discussion. The same approach was followed in the US. A few years later, the Commission took the same approach in Facebook, WhatsApp. So you will see that there the Commission tried to assess some
Konstantina, we are not hearing you.
ties.
Now I think it's back.
Oh, fantastic. Okay. So I was explaining a little bit the elements of the Facebook WhatsApp decision. And with Google DoubleClick and Facebook WhatsApp, we passed from the stage of denial to the stage of reluctant acceptance. And I'm clearly referring to a bunch of policy documents that were adopted in recent years. One may think of the European Strategy for Data, different communications adopted by the Commission, where the Commission makes reference to the data power held by big online platforms, large online platforms, and how this can affect competition. And essentially, the point that was made at the time was that, competition law has certain weaknesses that cannot be overlooked. For example, investigations that last many, many years. It's very difficult to prove dominance in data-driven markets, especially in markets where you have free products. And we may be needing, first of all, remedies, data-driven remedies, but also perhaps regulation. That was mentioned in the European Strategy for Data Communication back in 2018. And of course, then you had the Platform to Business Regulation 2019, where the EU established new requirements for transparency with respect to access to data. And of course, more recently, the DMA, which is what we will be discussing today. So it's very clear to me that times have changed, as correctly pointed out by Anna. But the thing is, will they change to the better or to the worse? And I think that this is where I would leave it for now and move on to the discussion, because we have a lot of things to discuss with respect to the DMA and the data-related obligations. Thais, I believe you're on mute. We cannot hear you.
Sorry. Thank you very much, Anna and Konstantina, for sharing with us such enriching thoughts and explanations. So, well, now we are open for Q&A. Would someone like to share any thoughts or address any questions to Anna or Konstantina? Because I have some questions, but first, does anyone want to say something? So for now, I'll bring here some questions, and each one of you who feels comfortable can answer to it, so we can hear a bit more. First, about the designation, I would like to ask. For Konstantina, I think maybe it's because of what she just said. So Konstantina, do you think that the European Commission assessing what makes for a gatekeeper could lead to an over-inclusion, seeing how it's only considered quantitative criteria in its analysis?
Thais, that is a very good question. And it has many nuances, and I think it's very important to distinguish between two different issues. First of all, the methodology for calculating user numbers under the DMA, which is, of course, something that will lead to designation decisions. And the second issue is the rebuttal. I wanted to make a few remarks on the methodology for calculating user numbers first. So I wouldn't be against quantitative criteria per se. This is one of the issues that the DMA is trying to fix, in the sense that it was very difficult to prove dominance under traditional competition analysis. And this is why the EU has opted for essentially establishing user thresholds. So in theory, one might say, well, this is very short and sweet. If a gatekeeper meets those thresholds, it notifies the commission, and then within 45 working days, the commission designates the gatekeeper. However, I don't think that this will be a very smooth process, because we need to consider how designation will take place. First of all, if you take a look at the DMA annex, you will see that many different metrics are proposed for each category of core platform services. This process and assessment will largely be up to the commission. However, gatekeepers have some leeway. First of all, because the DMA does not establish a specific metric for each category of core platform services. For example, in the case of online intermediation services, you can have concluded transactions as a metric, but you can also have the number of queries or queries as a metric. So I'm not sure how this is going to essentially work out in practice. I believe that the commission has its own views as to what qualifies as best or what is the best metric to measure engagement with the platforms. However, I don't think that this will be very straightforward. I think that gatekeepers will try to find out a way to
We cannot hear you now again.
litigation
We're not hearing.
Or
Konstantina?
heated regulatory dialogue. They think that even though the DMA has for inclusion, I'm not 100% sure that there would be, from the perspective of, avoiding the rebuttal process under Article 3.5. If you take a look at the provision, meaning the main text of the DMA, you have a very broad reference to the circumstances in the market. So that's great, because you say, okay, so somebody that initially qualifies as a gatekeeper can basically explain that the circumstances in the market are such that it shouldn't qualify as a gatekeeper, it shouldn't be designated. But then you have recital 23, and there, as you know, the DMA to qualitative criteria, for example, the size of the undertaking, the size of the market. And here we'll stick to these quantitative criteria, in which case we find a way to bring cases before the Court of Justice, in which case the Court of Justice will need to rule on whether, relying on quantitative criteria only makes sense, or whether we should also rely on qualitative criteria, in which case there is a high likelihood that we will avoid over-inclusion. So I'm optimistic from that perspective. And, it's not because I want gatekeepers to essentially avoid being designated as gatekeepers. It's just that we need to be reminded of general principles of EU law, such as the principle of proportionality, the principle of non-discrimination. So if we think of the fact that under the DMA, a company that does not meet the thresholds can still qualify as a gatekeeper on the basis of qualitative criteria, the reverse should also apply to companies that reach those user thresholds but still may not be gatekeepers in a given market. So it's about having the rules right, the basic principles right, and then the court, I believe, will essentially be requested to rule on that aspect.
Thank you very much. Now I have a question about the obligations.
Sorry, could I also add something to that question?
Sure, thank you.
Okay, thank you. From my perspective, and from the work I've done so far on the DMA with clients, I think that the DMA has a very narrow scope. There are very few companies that are actually in scope. I mean, we can name 5, which I won't name now, but the big 5 tech companies. They're the ones really in target, and the ones probably that are going to meet those criteria. So from the practice I've had so far, very few companies think that they're in scope, and the ones that are the big ones that know that they're in scope, they've been looking at this for quite some time, and they've been preparing themselves for it. Obviously, there's still discussion on like the criteria, on how to meet the criteria. Specifically now, I mean, not on the DMA, but on the DSA, which has similar criteria, specifically like for active users, how to count active users, which will also help companies that are subject to the DMA. There's discussions on like how to avoid counting bots, how to avoid counting users that access a certain service, like using smartphone and also computer, and also from what we have seen in the DSA, the European Commission has been quite over-inclusive and in respect to not only designating one certain entity in like which is the EU headquarter of a big company, but also designating their headquarters in US together with the EU headquarters as being subject to the DSA. And now the question is, will the same happen under the DMA? So will it apply like to the whole group of companies, the headquarters, wherever they are in Europe, and then the US headquarters as well. So these are discussions are going on, but from the work I've done so far, the DMA has really a narrow scope of application. And that's also reflected in the staffing by the European Commission. The staffing is not very high. There aren't many people working on like enforcing the DMA at the European Commission, just because there is knowledge that so far that it won't apply to that many companies. So that's my experience.
Thank you for adding that, Anna. Now, well, of course, both of you, discussion about the obligations and prohibitions in regards to data-related issues. Considering that the DMA and the DSA's goals of empowering data subjects, will the current emphasis on platforms promoting user-friendly consent really give back the control to individuals over the extent of their personal data? Gatekeepers can combine or cross-use. What do you think?
Should I go first?
Yes, please.
Yeah. Okay. Konstantina?
Very good. Well,
okay, thank you.
His popular opinion in the nation, everybody understands that. Similar to Article 5.2a, but I'm a bit perplexed as to whether the rule has been designed properly. And I will explain why. So, as you know, under the DMA, gatekeeper platforms should not combine data unless users grant their consent, right? However, I'm a bit perplexed about the second part of the obligation, the consent-related obligation. Why? Because under the GDPR, we have a principle, the so-called principle of informational self-determination that we need to consider. So basically, we want to be able to empower users to make decisions by granting their consent or not. However, the DMA, being economic regulation, and the same applies to competition law, should not be concerned about how we want users to behave, but how users actually behave. And not only referring to the privacy paradox here, yes, we all click agree, we never read our privacy policies of the also referring to many other factors identified by the Competition and Markets Authority in its digital advertising market report, where the CMA identified a bunch of other factors in addition to the privacy paradox. For example, dark patterns, including click-wrap agreements, and all these sorts of things, which show that even if consent is requested, that consent may not necessarily be compliant with the GDPR. Now, of course, the DMA says that this consent should be compliant with the GDPR. But the question that arises here, and I think it's a very legitimate question to ask, is who is going to enforce that obligation? So, and how is this obligation going to be enforced? For example, will the Commission start to assess compliance with the GDPR of the compliance reports that will be submitted under the DMA? Meaning, will the Commission start assessing the privacy policy of gatekeepers? Will the Commission be discussing with data protection authorities in the context of the high-level group that was created by the DMA? Now, of course, these are all discussions that the Commission should have with experts. But on the other hand, when we discuss the day-to-day operations of the DMA, how consent is extracted, does the Commission, and specifically the DMA task force, have the expertise to do that? And how enforcement will work in practice is something that is not very clear to me at all at this stage. It's going to be very tricky.
Anna, do you have something to add?
Yeah, sure. I agree with Konstantina. There are lots of questions on the effects of consent. I think that, like, on the one hand, it's interesting to see that the DMA emphasizes consent so much, because, like, from a privacy perspective, this is just one legal basis. There are many other, and clearly the DMA doesn't want companies relying on legitimate interests for a number of processing purposes, like for advertising, and also for combining data. So it's interesting to see. I'm not convinced, though, that consent will really help individuals, just because of the consent fatigue. We've seen it in other areas, like especially the cookie banners. I mean, this discussion is ongoing on, like, are cookie banners actually effective? People just click on them. And I wonder whether a better approach wouldn't be just to set out rules that, you know, make sure that gatekeepers respect privacy, and obviously also competition law, ensure transparency, and that individuals have a choice to, like, object if they don't want their data to become night objects. But that was not the choice by the Commission when drafting the DMA. Clearly, it's like consent-based. So what's going to be interesting is to see how this consent will be obtained, and then in addition to the whole requirements on consent under the GDPR, which companies really hate already, because it's like the standard is so high under the GDPR. You have to obtain freely given consent. It has to be informed, specific, ambiguous, and then making sure that it's you're not nudging users to give consent. Well, there are additional requirements under DMA to it, which is interesting because at least now there's, like, some more express regulation of dark patterns, which we don't have under the GDPR, and which is now appearing in many other laws, like the AI Act includes provisions on dark patterns, the ASA includes provisions on dark patterns, consumer law is wanting to address dark patterns. So it's very interesting to see that it's clearly a trend, and that the DMA was, like, one of the first here, but because the DMA actually says that requires online interfaces that they should not be construed in a way that they deceive, manipulate, or otherwise materially distort or impair the ability of end users to freely give consent. And gatekeepers should not be allowed to prompt end users more than once a year to give consent if those users said before that they didn't want to consent. So this is all is a good reason behind it, but again, it's all about questioning whether consent will be effective. We'll just see more consent banners in all those big platforms. And because the consent will not only cover what the gatekeepers do, so that their combination of data, or whenever they want to use data for online advertising, data that they collect, like, from the different kind of services that are on their platforms, but also there's, like, this one provision that's in the DMA that speaks about the different services on the big platforms can ask the gatekeeper for data. But in order to receive that data, they need to obtain consent from the end users. So there's, like, an additional layer of consent. So not even the gatekeepers, so the gatekeepers have an interest in obtaining consent, but also the different services on the platforms who also want to get consent. So how many consent banners can we get? I don't know, but companies are definitely looking into this now, because they're changing their interfaces, online interfaces, to make sure that they can accommodate to this. That's my take on the whole consent discussion. Thank you.
Well, thank you. About the overall design and objectives of the DMA, I would like to ask, in your opinion, should the DMA adopt a more flexible, individualized approach to cope with the reality of the digital markets?
Konstantina, do you want to go first?
Anna, please go first, because I have finally arrived, and I will finally be able to switch on the camera so that I can see you all. Go ahead.
Okay, Sure. I find this is actually a very difficult question to answer because the DMA like aims primarily at regulating the market from a competitional perspective. So I find that the DMA is mainly competitional, and then it inserts tools on privacy to regulate the markets. But obviously, then it also has to take into account privacy considerations. And the whole thing about being flexible and individualized, I don't know to what extent that would work to meet competition objectives. And on from a privacy perspective, we're not really very used to seeing a flexible, individualized approach either. It's like generally it's like principle based, and then you figure it out like whether you comply with the principles or not, which is better in a sense that you can't really get it wrong, because if you're very individualized, then you could get it wrong. So in my experience, the more flexibility, the less legal certainty and the worse for everyone. And I'm talking about like for companies because of the legal uncertainty, they don't know what to do. And then for individuals, because again, compliance is then made more difficult.
Thank you. Konstantina, would you like to add something? Konstantina? Well, I think Konstantina had a problem with the connection, maybe.
Guys, can you hear me?
Oh, now, yeah.
Perfect. So I just wanted to make a few points on, this individual or case-by-case assessment. I think that we need to make two remarks here. First of all, how competition law works, right? Competition law essentially relies on two provisions. Article 101, Article 102, this is antitrust control. Of course, we rely on a case-by-case assessment because this is how competition law has always worked. We need to take into account specific market conditions. Now, the DMA will not necessarily work like that. However, when people say, well, the DMA is not flexible at all, it doesn't take into account several factors, it's drafted in very narrow terms, and, some of these prohibitions should not apply. I don't necessarily agree that the DMA is designed in a way that is not flexible, and I will explain why. First of all, we have two main principles to work with: fairness and contestability. Now, clearly, these principles need to be essentially given flesh by the Court of Justice in the context of litigation. So we expect that to happen. Secondly, in addition to those principles, we have the obligations set out in Articles 5, 6, and 7. Now, some of these obligations will not apply to specific categories of core platform services because they're not relevant. For example, the prohibition of self-preferencing in ranking does not bind operating systems. So it was clear that the legislator made a choice there that this prohibition, whether I agree or not, is a whole other issue. However, the legislator has made a choice, a specific choice, to individualize this prohibition to specific core platform services. In addition to that, and this is something that many people tend to forget, we won't have only the principles, then the obligations and prohibitions, but we will also have the compliance reports submitted by the gatekeepers that the Commission will assess. Essentially, this is very similar to the codes of conduct that the UK is currently considering introducing vis-a-vis Google and Google, Facebook, and the other platforms that will be designated as platforms with strategic market status under UK law. So I think that from that perspective, the DMA is quite individualized because the principles are vague enough to be given flesh by the Court of Justice. The obligations and prohibitions have been designed in a way that apply to specific core platform services. Then you would have the compliance reports that will be assessed by the Commission. And the other 2 points that I wanted to make with respect to the DMA is that you may remember from the text, the DMA allows new practices and new gatekeepers to be included, or new core platform services to be included to fall in scope, subject to a market investigation, the adoption of facts, and so on and so forth. So I think there is a lot of flexibility built into the system. How the system will work is a whole other discussion. However, I cannot say that the DMA lacks flexibility to take into account individualized circumstances specific to core platform service.
Thank you for sharing such great thoughts. Well, my next question would be, if you believe that the DMA centralized enforcement model is the best option to promote the DMA's goals, or do you maybe believe that a more decentralized model in which national authorities are empowered would be the best option?
Konstantina, do you want me to go first? Okay, I'll go first then. So I have to answer this question from a privacy perspective because I'm less knowledgeable on competition law. But from a privacy perspective, there's a lot of discussion on the whole one-stop shop under the GDPR and how regulators, especially in cross-border cases, have to work together and how this delays the whole process, the procedures, investigations, and then lastly also the penalties implementation law. So maybe this is the solution, having one centralized body, the European Commission, being the one enforcing the DMA. And it seems like this is already what's happening under competition law, and it works. And I've had a brief discussion with my competition law colleagues, and they mentioned that it has been like this for years, and it works. So given also the limited scope of the DMA, since it only applies to a few companies, probably a centralized approach is preferable. But again, I'm looking at it from an angle from data protection and not really from GDPR. So from data protection perspective, this approach seems to solve like foreign shopping that we have in data protection, how some authorities are being overwhelmed with cases compared to others, and then it creates issues between authorities, and then also like the lengthy negotiations between authorities and the delayed resolution of cases. That's my perspective from data protection. From competition law, yeah, it's my colleagues say it works, but I really don't know.
Then I think I should give the competition law perspective. That is a very good point, Anna, and I think you're absolutely right about the enforcement of the GDPR. It's a thorny issue to discuss. Nevertheless, I think that given the centralized model that the DMA currently follows, I think that it's important to take a step back and think of how competition law used to work. So if you remember, in the very early days of competition law, you would only have the commission, and the commission would essentially do everything. At the time, before the modernization of competition law and before the process of self-assessment, whereby companies self-assess their conduct and then they realize whether an agreement that they conclude with another undertaking or whether the position that they hold in the market may be a dominant position, and therefore this raises issues of special responsibility. Before we entered into the process of self-assessment, the Commission would do the entire work. And that was a centralized model, and the Commission, of course, at some point felt completely overwhelmed. It was completely overwhelmed with notifications about agreements. It was completely overwhelmed with cases regarding abuses of dominance, and therefore the decentralization process happened and Regulation 1/2003 was adopted. So I cannot exclude that in some years from now, the same thing might happen with respect to the DMA. And for that specific period, for that first generation of the DMA, I personally do not think it's the worst idea in the world to have a centralized authority to deal with these issues. Why? Because I think that the Commission is quite close to these issues. It has assessed many cases. It has dealt with many cases regarding abuses of dominance, as everybody knows. DigiConnect has dealt with a lot of issues concerning digital markets. For example, DigiConnect was one of the main directorates that worked on the platform to business regulation. The expertise is there. One thing that I am concerned about is the staffing of the Commission. Whether the Commission, as a centralized authority, to essentially enforce such complex obligations, and of course, we can expect a lot of litigation, a lot of complaints will kick in, whether the Commission will essentially have the necessary financial and human resources to actually do the work. This is where my primary concern lies. However, in the future, I would not exclude a model similar to the one we have in competition law.
Okay, thank you very much. Well, now, considering the digital single market and the data-driven economy purpose. Do you think that should promoting innovation be considered as an objective itself, or should it be a byproduct of contestability?
I would ask Konstantina to start with this one because it's very like competition based.
You know what? I'm not even sure, Anna, whether it's competition based, but I'll give it a try. You know, it's a very good question. It goes back to the foundations of the DMA, the objectives pursued by the EU with respect to the completion of the digital single market. It raises a lot of issues regarding principles that in theory are protected by EU, for example, fairness or non-discrimination. So it really is a very tricky question to answer. I don't want us to get lost in the philosophical aspects of the question. However, one thing that I was thinking as we were discussing and preparing for the seminar is what I saw many, many years ago when the Commission launched its digital single market. And at the time, and I believe that this is still there, the statement is still there, the Commission mentioned that the digital single market is about lowering barriers to entry. So essentially about making digital content, digital services essentially circulate across the EU. Now, if we consider that this is the objective of the internal market, of the digital single market, to lower barriers to entry so that digital services can circulate freely across the EU, then I would say that this is the purpose pursued by the contestability goal of the DMA. And in the DMA, in the text, you may have seen that there are many recitals referring essentially to a definition of contestability to the extent that one can define contestability as essentially the idea that it's about lowering barriers to entry. So from that perspective, if I were to approach the question from that perspective, I would say the objective of the digital single market is to lower barriers to entry. Contestability is about lowering barriers to entry. Therefore, innovation should be a byproduct of that. However, when we read, and I think that this is where the answer lies, at least from my perspective for now. However, it's not so straightforward because you may have seen in other recitals of the DMA where innovation may be referred to as an objective in its own right, an objective of the digital single market again. So it's really not clear. However, I was at a conference last week regarding the DMA, and one thing that resonated with me was the following. Unless you define very clearly fairness and contestability, meaning coming up with specific parameters against which to measure the success of the DMA, innovation being one of them, how can you say whether the DMA will be successful or not? So I think that on the one hand, this is a philosophical question, but on the other hand, it's also a very practical question, meaning a question with huge practical implications for what the DMA will mean.
I completely agree, Konstantina. And in my preparation, I also thought, well, innovation is clearly a byproduct of the whole DMA. And then moving from a privacy perspective, innovation is never like really the focus. The focus is, at least from a privacy perspective, protecting privacy and data protection rights of individuals. And again, also there, innovation is something that is considered, obviously, because, for example, you have sandboxes and you have net neutrality principles, and you have principles that clearly you want to ensure innovation, but it's not really the focus. But I understand that the whole like regulation of privacy, it does put a strain on innovation, and that's like what most companies complain of, that in Europe there's too much focus on regulating rights and sometimes regulators forget innovation.
Anna, if I may, because you gave me an excellent pass now, and I wanted to discuss innovation from that perspective, because when we discuss innovation in the context of the DMA, and whether it's a byproduct of contestability, whether it's an objective in its own right, one should also consider innovation of whom are we talking about? Because I think that the DMA, tries to strike a balance between essentially regulating platform conduct, meaning putting restraints on platforms to ensure that smaller companies can innovate, right? It's not only about the innovation of gatekeepers. And I think that, even those that are proponents of the DMA, myself included, will never say that platforms are completely useless. Our lives would be much better without them. We clearly understand, the innovation that they brought to our daily lives. However, when we talk about contestability and innovation from the perspective of smaller companies, one needs to consider that smaller companies also need a chance in the market. So I think we also need to consider, the trade-off between innovation of gatekeepers and innovation of smaller companies. And that could also, answer or go part way towards answering the question regarding the role of innovation in the context of the DMA and privacy regulation.
Absolutely, and that's how I saw it in the impact assessment of the DMA. It always talks about innovation of small and medium companies and not really of the gatekeepers who are being regulated now, so they may curb their innovation, but it's in the benefit of others. So,
absolutely.
Well, thank you for giving us such an interesting class. Those are really interesting points. I would like to ask also, do you think that DMA text raises questions about the separation of powers of the institution of the European Union, considering that the European Commission defined the rules while also making itself responsible for investigating violations of said rules and sanctioning said breaches?
I mean, Anna can speak from the perspective of data protection regulation. However, when I was reflecting on that issue, I think that from the perspective of competition law, this is not something new, in the sense that in competition law, as you know, the European Commission will initiate an investigation, then it will adopt a decision, then it will impose a fine. So this system is quite, is definitely not new in the EU. And of course, a lot has been written about, the separation of powers, how it is important to make sure that the Commission respects certain fundamental principles, because clearly companies have fundamental rights, and therefore those rights should be respected. And we may also want to consider the, how competition law enforcement has evolved. We may want to consider the role of the hearing officer. And perhaps I can take a couple of minutes to make a remark on this. So as you know, the DMA currently does not envisage a hearing officer or any officer of the same, type that would essentially contribute to ensuring that fundamental rights will be protected. However, I would not exclude it in the future. So I would perhaps not see a hearing officer be established now for the process of designation, but for the process of compliance, where gatekeepers need to go to the Commission to make their case. And for business users that will go to the Commission to submit a complaint and also make their case, I could definitely see how this thing will evolve in a way that is similar to competition law.
Great. Anna, would you like to add something?
I agree with Konstantina. Actually, I have never heard this concern in practice, but I look at it again from a privacy perspective, and we don't have the same regime, so the European Commission would not be the enforcer. But I haven't heard concerns on separation of powers as being something that's being raised in relation to the DMA. And I think it's due to the history of how European competition law is currently enforced. It's already being enforced by the European Commission, so it's not really a major change, I guess.
Okay, thank you. Going back again for two more questions to the obligations and prohibitions, I would like to ask if you think that can the data combination prohibition under the Article 5.2 really be a self-executing obligation?
Anna, would you like to go first? Shall I give it a go?
Give it a go.
Perfect. So the short answer to that question would definitely be a no. First of all, if you remember the original proposal prepared by the Commission,
that was a very small obligation. Then during the legislative process, it became a humongous obligation. I mean, it's literally 1 page long. So when you go through it, of course, many questions arise. And I will just give you a specific example. And of course, Anna is better placed to talk about that example. But when we talk about consent, what exactly do we mean by GDPR compliant consent? And I will give you just one example. The EDPB, the European Data Protection Board guidelines on consent are 30 pages long. So only on consent. So that already gives us an indication as to, the concerns that may arise, the questions that may arise from the interpretation and implementation of that obligation. Of course, when you go through the recitals, so you will see that there are many, many different issues that arise. For example, if the user does not grant their consent, then the gatekeeper should offer a less personalized alternative. What does that mean in practice? That's another question that arises. Then, of course, you go to recital 37, which I have in front of me, and I read, when the gatekeeper requests consent, it should proactively present a user-friendly solution to the end user to provide, modify, or withdraw consent in an explicit, clear, and straightforward manner. What does that mean again? So, I don't want to go on and on with examples, but I think that the obligation is so complex. Let's be reminded of the fact that in the final text, we also have advertising related issues there, which are very complex in and of themselves. And then when you go to the implementation stage, I cannot see how the gatekeepers will not have questions to discuss with the Commission in the context of a regulatory dialogue, which in theory is not about Article 5 obligations. It's reserved to Article 6 obligations subject to further specification. And I cannot see how this will automatically be implemented in a magical manner without discussing and resolving all these thorny questions around consent and other vague terms with respect to the implementation.
Absolutely, and that's actually where our competition colleagues come and call us the privacy lawyers, because there's all this, there are all these questions on like, what does it mean? How do you obtain this? What does it mean that there will be degradation of the quality, but you have to inform the individuals that it's not personalized because the individual said that they didn't want the personalized experience, they didn't want to give data for it to be personalized, and in addition to these EDPB guidelines on consent, which are already extremely long, there's also EDPB guidance on dark patterns, which is even longer. So, and then you have ongoing enforcement here in Belgium on like how to record that consent and how big companies are meant to do so. So obtain it and then share it with all the other companies, and they make it even more difficult to rely on consent. So generally, companies avoid consent. Now, clearly, they can't avoid consent under the DMA. They will have to rely on it. And it all means, what does it actually mean? Well, that's, they will be very carefully drafting their online interface consent banners to make sure that all the requirements are met. And I'm sure there's going to be litigation related to this on the standard of consent.
But if I may, Anna, just a question: will they be so careful when they draft the privacy policies to extract consent? That's my question, because it's one thing to basically present something to the Commission that seems convincing. It's a different thing how this will apply on a day-to-day basis. This is where my concern lies. Yeah.
That's true, but I think companies are particularly scared now because there's also this other provision in the DMA that talks about sending reports on how companies do profiling on a 6-month basis. So this means that finally the regulators will have access to how they're doing profiling. I mean, this is the dream of data protection regulators. They have had so many difficulties understanding how these big companies profile users for advertising, for example. And now they will receive this information because it says that the Commission will share this information with the EDPB, who will then share it with the data protection enforcement authorities. So now they feel the scrutiny. They feel much more, okay, well, if I will have to disclose that I do all this profiling, so clearly the Commission will look at the consent I obtain. And the consent obviously should always be as commercial as possible, so as user-friendly as possible, to make sure that there as much consent given as possible as well. But at the same time, there's now clear instructions on that consent, and certainly there will be more guidance coming on consent, and then there will be litigation on consent. So it's going to be a big topic. For
sure. And it's a very good point. I wanted to make a follow-up point on this. It's very interesting that you mentioned profiling and the obligation to basically prepare these reports and submit them to the Commission. I was reading the CMA report on digital advertising, and what struck me is that the CMA would essentially ask the big platforms how they assess engagement of users with their privacy policies, and more generally with how they users give their consent. And it struck the CMA at the time that platforms would not actually measure that sort of engagement. So they were very keen to basically extract the consent, but then there was no empirical evidence regarding the extraction of consent and more generally engagement with the privacy policies. And I think, based on what you just said, that this is going to change now with these profiling reports.
I think it will. I think it will, because regulators have been looking for this information for a while, the whole profiling, and really want to stop companies using legitimate interest for it. And many companies are still relying on legitimate interest. So now we will be much more consent-based. But looking at the obligation to provide information to the European Commission on profiling, like it's really specific and on data protection, because it talks about an independently audited description of the basis upon which profiling is performed. So whether the profiling involves personal data, the processing applied, the purpose for which a profile is prepared and eventually used, the duration of the profiling, the impact of such profiling on the gatekeeper services, the steps taken to effectively enable end users to be aware of that profiling. So more transparency on profiling, not just like a paragraph in a privacy notice. And then steps to seek their consent or provide them with the possibility of withdrawing consent. This Article 15, and then together with Recital 72, has been really the focus of many companies.
Can I ask you a follow-up question on this? So basically, you referred now to the profiling-related obligation of the DMA. So clearly, as the obligation currently stands in the DMA, this is merely a reporting obligation. So it's about being transparent about how you profile users. However, if we consider the high level group that was created through the DMA, which will encompass consumer protection authorities, data protection authorities, competition authorities, and so on and so forth, I was wondering whether you think that those reports will essentially contribute to a more effective enforcement of the GDPR.
Absolutely. I think because there's an obligation for the Commission to transfer the audited description to the European Data Protection Board and to inform enforcement of Union data protection rules. So there's clearly going to be a sharing of data, and there's a clear fear that the EDPB will use this for enforcing.
And how do you see the one-stop shop rule with respect to jurisdiction aspects? I mean, should we still be concerned about, everything falling on the shoulders of the Irish Data Protection Commission?
I don't think that will change. It doesn't change. The DMA don't change the GDPR rules on that. So it will still be some authorities that will have to deal with those cases. And those authorities, as by the report by the Irish DPC, are already super busy with many cases. I mean, looking at the latest report, they don't even mention some of the cases that were in the past report, and they're still ongoing because there's just so much going on, and they feel the pressure.
But essentially, I think that we are both hopeful that this will lead to more effective enforcement and understanding of how profiling takes place and how users engage with privacy policies.
Yes, and I think it goes back to the questions like, is consent the best approach to deal with ensuring that profiling complies with data protection? I'm not convinced, because it's just having individuals every time with a pop-up consenting to this is not really the best way. Probably in my opinion, making sure that when companies are doing profiling, that they respect the rights and that you have an option to say, no, I don't want my data to be profiled, is better. But that's not the approach that the DMA took. So it's consent.
But if I may, just a quick point on that, because this is actually something that I wanted to mention when Thijs asked us about Article 5 and more generally, and more specifically, the data combination prohibition. I think that consent should not be a topic of discussion or, included in the provision at all. I think that for many different reasons, data silos would have worked better. So basically, to have a clear-cut data combination prohibition along the lines of Google Fitbit, along the lines of what the CMA is discussing. So clearly, this is not something new in competition law enforcement or in the discussions that policymakers have had over the past few years. Thijs, I understand we overtook the discussion from you, but actually, yes, please go ahead.
I was going to say thank you so much for such a lively and rich discussion. It was really, really interesting. I was amazed hearing that both of you speaking about your experience and thoughts. I would like to ask, but you just touched upon it at some point you raised. How do you see the overall framework concerning data issues? Example given Article 6. And
I can give the perspective of competition law. So I've already discussed Article 5.2, why consent doesn't work. Anna has already discussed that extensively. Clearly, one might say, well, you shouldn't be that pessimistic about, how consent ended up in the DMA. But I think that we need to consider Article 5.2 in combination with all the other data-related obligations or prohibitions included in the DMA. And I think that here it's worth making a couple of points because several issues are not clear to me at the moment. For example, the Amazon prohibition, whereby gatekeepers should not use data in competition with their business users. This term, in competition with their business users, is not clear to me at all. Why? Because the DMA does not rely on market definition. Therefore, how can you identify which gatekeeper is in competition with what business user if you don't rely on market definition? And the other issue that arises, which is still not clear from this specific obligation or prohibition, is, are we talking about in competition with business users that already offer products similar to those offered by the gatekeeper, or products that do not exist yet? So, for example, products that the gatekeeper is envisaging offering, or business users envisage offering based on big data analytics performed by the gatekeeper. So that's also not clear. Are we talking about existing products or about future products? So therefore, my conclusion on Article 6.2 is that it's not clear to me at all how this will apply in practice. Now, with respect to the other obligations, I will make a couple of remarks on data portability, Article 6.9. So as you know, the DMA establishes this requirement to offer data portability. It establishes requirements that, in my view, are stricter than the GDPR. But the key point remains the same, which is that the DMA relies on end users requesting data portability. And this brings me to the point that I made about Article 5.2, that you cannot rely on the user to basically ensure fairness and contestability in digital markets. First of all, because this is a huge burden to bear for the end user. But secondly, because this is not how users behave. So if we take a look at, the GDPR implementation report, we will see that data portability has not reached its full potential. And I don't see how this will change in the coming years. I'm not even sure whether the majority of users is actually familiar with data portability as a right under the GDPR, and whether this right is something that concerns them that they want to exercise. And one final remark on Articles 6, 10, and 11, which is essentially about mandated access to data. And I think that this is one of the most controversial provisions in the DMA. To me, it's very clear based on the work that I've done and legal advice I provided that, access to data is something that absolutely had to be dealt with under the DMA. So I agree with the main principles. Now, how these principles will apply in practice is a whole other topic. Under Article 610, you would have an obligation whereby the gatekeeper would need to provide to business users high quality data. What does that mean? Then, under Article 611, a search engine that qualifies as a gatekeeper needs to give data to another search engine under fair, reasonable, and non-discriminatory terms. Again, what that means in practice remains to be seen. So I think that with respect to the data-related framework under the DMA, we can expect a lot of litigation because the terms are very vague at the moment.
I completely agree again, Konstantina. I'm going to pick up on the rights of portability, and then I'll follow with a brief commentary on 6.8 on sharing data with business users, advertisers, and search engines. So first on the right of portability, it's, in my experience, it's not really a right that's been exercised that much. Again, as Konstantina said, most probably data sources don't really know about it, and it definitely goes further than the GDPR. There are three main differences. The first one is it covers not only data that is provided by the data subject, but also data generated through the activity of the end user. And secondly, it requires not only providing the data to the third party at the choice of the end user, but also continuous and real-time access to such data. How will this be done? Is it going to be done like through an interface that is dedicated for this, or do these big platforms, so gatekeepers, need to engage like a third-party platform that's specialized for sharing this data? So these are all questions. And then thirdly, like obviously the legal basis for this sharing in this case will be the DMA. So the DMA requires sharing this data with a third party at the request of end user or third party authorized. I'm very curious to see how much, whether this is going to be exercised more than the GDPR. But it clearly, the obligations are more stringent.
Anna, you give me a good pass, because as I was reading the data portability obligation under the DMA, I also read the recital. In the recital, the Commission, from the proposal it published, it really tried to convince us, and of course this remained in the final text, it really tried to convince us that the right to data portability under the GDPR is essentially the different side of the same coin under the DMA, the obligation under the DMA. And I'm like, how is this going to work in practice? For example, let's assume I'm an end user and I want to exercise my right to data portability. As you correctly pointed out, the right to data portability under the GDPR is very different from the right to data portability under the DMA. Will a banner pop up and tell me which right do you want to exercise? But I mean, the GDPR has been around for a longer period of time and users are not familiar with it. So given that the DMA goes, further than the GDPR, as you correctly said, in theory, I would be given more protection as an end user if I exercised this right under the DMA. So my question is, how will this work in practice? And how can we expect users to know about data portability issues under the DMA and how to choose?
Very good questions. I don't have an answer to them. Indeed. So maybe moving on to the second topic I want to discuss, which was Article 6.8 and then 10 and 11, which is about gatekeepers sharing personal data with business users and third parties, and also with advertisers, and then lastly with search engines. So I understand that the sharing of personal data by gatekeepers it's really just with business users and with advertisers and publishers. So with business users, again, it's the way that the data is shared. Well, it says that it has to be free of charge and in real time again and continuous. So it's all about making sure that there's a platform that connects business users with gatekeepers, and this platform may not be provided by the gatekeepers itself. There may be like specialized services providing those platforms. And then the basis here being consent, which I've given enough criticism to that. But then moving on to sharing data with advertisers, which is very understandable as well, because advertisers want to know how many times end users have clicked on their advertisement, how engaged they are by their advertisement. But surprisingly, the DMA doesn't give a legal basis, or it doesn't expressly say, it doesn't talk about consent. So what is the legal basis? It's like, is it a legal obligation? So can I just say, I have an obligation, I don't need to do anything else to share the data? That's again a question. And then thirdly, sharing data with online search engines. It talks about just sharing anonymous data. So there, we're not talking about personal data anymore. And here, major, big questions like, what is anonymization? We have this question in so many other areas under the European health data space. We're having this question as well, but it's just, there's no standard for anonymization right now. It's a big struggle for companies to achieve anonymization, also because it's not, the regulators are not taking the same stance on it. The EDPB is working on guidelines anonymization, but they're also working on a number of many other guidelines. So it's not clear when those guidelines will come up and to what extent those guidelines are going to be better than the Article 29 Working Party guidelines on anonymization, which were very stringent, and well, they have to be ignored in order for just market to continue. So I hopefully the new guidelines by the European Data Protection Board are going to be pragmatic, and hopefully also the European Commission will come up with some guidance. We'll work with the DVB on achieving guidance on what does it mean to anonymize data, and we'll finally stop advising clients on like anonymization because it's such a hard thing to do. These are my
but it's also very complex and costly, right? So it raises a lot of questions. But Anna, you mentioned compliance with the legal obligation as a legal basis, and I was wondering, precisely because you referred to the issue of advertising, I mean, and we know that legitimate interest has not been a very popular legal basis for the purposes of advertising, right? So what do you think around the legal basis there? Would we, or can we expect the Commission to prefer consent? Or do you think that the DMA does not refer to a legal basis on purpose because they want to rely on other legal bases under the GDPR?
Are you referring specifically to the gatekeepers sharing personal data with advertisers?
Yes.
Or, okay. So there, it didn't refer to a legal basis. I don't know what's the reasoning behind it, but better than relying on legitimate interest would be just relying on the obligation to share data. There is an obligation. So you could, I mean, the argument would be, why rely on legitimate interest, which has the whole issue with balancing of interest, and you have to do a legitimate interest impact assessment. It can be contested by regulators. So if I were a big company, I would just say, well, I have a legal obligation to share the data.
Short and sweet.
That's right. Well, let's see whether it's accepted by a regulator. So
it makes sense. It makes sense, though, because legitimate interest has been frowned upon, as discussed.
Well, again, Anna and Konstantina, thank you for sharing such instigating thoughts with us. Those were all the questions I had for now. So I would like to ask if someone maybe would like to share any thoughts or address any questions. Anyone?
You can also make comments on what we said and be critical. You don't need to agree with us.
No, but for me, it was just really, really interesting to hear, because when I had the classes at the master about the DMA, I was a bit confused about some points, and the teacher pointed some criticism about it, and then I read about it to write a small paper on the class, and I was really, really confused because, as you said, the intentions are really, really interesting, and we need some regulation like that to make things work in a more fair way. But it's really hard to understand how it's going to work in practice. And it's nice to hear someone that, both of you, who actually are dealing with it already. So we can understand some things, and other things we keep asking ourselves. And I think it's just, as you said, time and waiting to see some other questions. So
that's a very good point, Thais. I mean, this is what we tell clients, you know, like, now everything goes, there's no precedent.
Yeah.
all interpretations are possible.
Yeah. So thank you again, both of you, for accepting our invitation and for sharing such great thoughts with us. And thank you again, everyone, for your presence today with us. I think if we don't have any further questions, we can end our session here.
I'm also taking the opportunity to thank everyone for attending so late, and most importantly, you for inviting me. It was a pleasure. And many thanks, Anna, for an interesting and stimulating discussion.
Same. Thank you so much for this panel and for being able to discuss this topic with Konstantina and with all of you. Thank you.
Thank you very much, Konstantina, Anna, and thank you also, Thais, for your moderation. So we will be back next month with a webinar in Portuguese, like Francisco said at the beginning. The webinar will be about data protection in the courts, I believe, and we will have also 2 guest speakers. So once again, thank you very much. Have a lovely evening, and I'll see you in the next webinar. Thank you. Bye-bye.
Bye, everyone.
Thank you.
Bye-bye.